It's before we launch into the next session, the substance of the next session, I just wanted to take a brief opportunity while people are getting settled to introduce you to another, some of you have met him already, another important part of the organization of this event, the editor-in-chief of the Osgoode Hall Law Journal, Professor Stephen Wood, our colleague. So Stephen's been an important part of organizing this event, and glad to see you, Stephen. So this is our penultimate session in the day, our last panel, Social Justice and the Limits of Rights Constitutionalism. We're delighted to have Gavin Anderson, an alumnus of Osgoode and a great writer on constitutional rights and social justice from Glasgow, visiting with us. Margot Young from the University of British Columbia, who's continuing her wonderful work in the area of social justice and challenges of constitutionalism. And of course, also delighted to have our friend Jenny Dudelsky from the University of Toronto. So we'll proceed as we have in the last panels, and perhaps we'll begin with you, Gavin.
Okay. Well, could I again begin by thanking Ben and Jamie and also the journal for the invitation to come here today. When I received the invitation from Ben earlier in the year, I pointed out to him it wasn't just the 30th anniversary of the patriation of the Canadian Constitution, but also the 20th anniversary of my enrolling as a graduate student in this law school. So a happy coincidence, and very, very nice to be here and to be in such illustrious company. I'm going to talk today about the new borders of the constitutional, and in particular my focus is on the past and potential future of critical scholarship under the Charter in general in particular, but also Bills of Rights, constitutionalism more generally. I was speaking to Lisa Phillips yesterday evening at dinner, and she began by saying that she had enjoyed reading my witty paper, and I felt a wee bit like Jim Hacker when Sir Humphrey Appleby would say, "Courageous decision, Minister." I wonder quite why she thought it was witty, and I wonder whether the wit that was found was the idea that there was a future for critical scholarship under the Charter. But nonetheless, I will proceed and deliver the paper. I'm really taking as my point of departure today a distinction that Jim Tully draws that I find very helpful, which is a distinction about two types of debate. And we've already heard some particular instantiations of this earlier. And that's a debate in terms of a distinction between debates over and within the prevailing constitutional rules. And my interest in critical scholarship is that I see critical scholarship operating at a meta level, not just focusing on debate over the rules, but over what it means to engage in debate either over or within the constitutional rules, and to do this in particular with a focus on the relation between constitutionalism and power. And my argument in the paper, and I want to advance today, is that the ways in which the initial critical response to the Charter sought to engage debate over the rules, which initially placed issues of legitimacy very much to the fore of debate, can be seen in retrospect as sustaining, or at least not preventing, the parameters of debate now being within the rules set by liberal democracy. So my puzzle in the paper is to work out why this was the case, and hopefully from doing that to articulate ways that we might reorient critical scholarship to debate over the rules. And in making that inquiry, I draw a distinction between what I see as the former borders of the constitutional and potential new borders. And I suggest in the paper that the former borders were constructed over three principal sites of battle. And those were the borders between rights and utility, between the private and the public, but overarching those between law and politics, or in parlance adopted in the UK, between ideas of legal and political constitutionalism. And I demarcate three phases in the first 30 years of the Charter, three phases of critical scholarship. The first is ex ante, pre-enactment, which is principled opposition to the idea of a charter, so to try to head off the entrenchment of a Bill of Rights at the constitutional pass. The second phase, which I think was sustained for at least the first half of the Charter era, is when critics move into an I told you so mode of arguing, where the theoretical abstract concerns that motivated the first phase are then revisited in the concrete context of actual jurisprudence. And the attempt here, I argue, is to keep the focus very much on debate about, not within the rules. And in its strongest form, this critique argues that the various divides that I've mentioned, rights utility, law politics, public-private, are themselves incoherent and need to be transcended. And so in its strongest form, this moves critical scholarship to the second aspect of that divide, so favouring utility over rights, favouring politics over law, and favouring invigorated public or state sphere over protection of the private. And the objective here remains, even if it's still theoretical, supplanting, even repealing the Charter. So in the first and second phases, the prospect is to move to a different form of constitutional rules. And how I characterise the third phase is that we then see almost a grudging acceptance that the Charter is here to stay. I don't know if you ever wrote it down, but I do remember Alan Hutchinson once referring to the Charter as being the only game in town. So there's a certain air of resignation here. And I think this raises various dilemmas for critics. Do they vacate the constitutional ground? Do they simply take the battle elsewhere? Or do they try to engage from within? And if they do try to engage from within, are they open to the risk of co-options? There are twin dangers that I see applying here. One of structural fatalism. This is as far as we can get in the critical project, withdraw. But the other danger is co-option. That once we critics move on to the ground that they previously critiqued, they themselves are open to the petard hoist that their own arguments can be used against them. And I think two interesting things happen during the second half of the initial Charter era. First is a certain qualification by Liberals of supporters, enthusiasts of the Charter on these various divides. So in the rights utility argument, for example, it's conceded that rights themselves may be based in consequentialist reasoning. On the law politics divide, we move from a defence of objective right answers to adjudication to the idea that there is a give and take between the legal and political branches, given expression in Canada through dialogue theory. And in the public-private, more a sense of the malleable nature of that line, and for example, the publicisation of the private being as much an option as the privatisation of the public. And in response to that, critics themselves have moved within these lines. So trying to argue for a different redrawing of the public-private line, to try to argue for a different way of imagining the link between law and politics. So in the paper, I refer to work of my colleague at Glasgow, Adam Tompkins, who's trying to carve out a role for the courts, but within the political constitution. So rather than arguing in terms of constitutional interpretation, what he seeks to do is to carve out a limited role for courts, who should protect, in his argument, absolute rights, but not qualified rights, because that moves onto the territory of legal constitutionalism. But what I argue in the paper is once this happens, the critics are effectively drawing themselves onto the ground of liberal constitutionalism. And so once they accept there should be some, moving to the obverse of the liberal move, once there should be some protection of rights, some protection of the private and the national security field has given real problems, I think, for critical scholars around the public-private divide. The private becomes the critical, the progressive node in that dichotomy. And similarly, within law and politics, to argue for a political role for the courts within the political constitution still empowers the courts within that setup. So in the second half of the paper, what I try to do is to carve out ways of moving the borders of critical debate away from these poles of the first 30 years and suggest that this can be reoriented in two ways. Firstly, by developing some of the insights of an emerging school of constitutional sociology, and secondly, by adopting some of the insights of post-colonial theory. And my argument is that although sociological and post-colonial perspectives have traditionally been seen as marginal to more normative or normativist approach to constitutional scholarship, from a critical perspective, they were always central, and it is important to see the ways in which they can become central. So I want to say just 5 minutes left, I think, just a few words about each of these. So firstly, the sociological turn in constitutional scholarship. This, interestingly, has largely been developed by European scholars. So I'm thinking of people like Günter Teubner, Hauke Bronkhorst, Jerzy Prieban. But in the paper, I concentrate on the work of my colleague in politics at Glasgow, Chris Thornhill. And Chris Thornhill has developed a very interesting sociological history of constitutions. And his project there is to move away from what he describes as normative deductivism, the idea that the constitutional scholar should be working out the ex-ante principles that guide constitutional development and then assess or prescribe particularly judicial developments in terms of their fit with those principles. He eschews that in favour of a project that looks at the motivation behind the recourse to the constitutional form. And I suggest that this gives us a different perspective, a different take on the question of legitimacy. Rather than seeing legitimacy as something to be established ex ante in terms of the normative argument, it's necessarily ex post and also inherently contingent. And so legitimacy of constitutions, on Thornhill's reading, depends on the extent to which they discharge certain functions he associates with them, functions of abstraction, generalization, depoliticization, and positivization, which he argues have been the uniting, the common features throughout modern history, and which explain the general recourse to the constitutional form. And I find this persuasive at a descriptive level. I find it helpful in reorienting constitutional scholarship and discourse to questions of power. I think it moves us from a normative discourse much more towards a genealogical inquiry into the nature of power. But I find it has some limitations. And those limitations, I argue, are related to its potentially circular and self-referential nature, in that the questions of validity, to a large extent, are generated by how constitutions themselves have developed. And so I think there's a risk there, although the questions of power come to the fore, that validity and legitimacy almost becomes a question of efficiency, how well these functions are discharged. So the second move that I suggest in the paper is to, as well as develop a sociology of constitutionalism, to link this to a sociology of Western modernity itself. And I have 90 seconds or just less to develop such a small project before you. But to do that, I draw on the ideas of Partha Chatterjee in the paper, and I may have to develop this more in discussion or in response to questions. But Chatterjee makes a number of distinctions which I think are very helpful in, potentially very helpful in the constitutional context. And these are between, on the one hand, a symmetrical view of modernity, which suggests, which is very much from the universalist narrative that sees modernity as a project to which all of humanity, all of society is moving towards, and that there are various exceptions or deviations from that, but those can always be explained and justified, and also justified within constitutional design. So, for example, the denial of representative democracy to former colonies shouldn't be seen within that mindset as abandoning a universalist framework. Rather, it involves a narrative around exceptions and deviations, whereby once such societies are ready, they can be given such institutions. And I think there were parallels of that type of reasoning brought to light in John's paper. And he also makes a distinction between different types of time. So he suggests that for the symmetrical view of modernity, time is homogeneous, developing the same for everyone, whereas in the sequential theory of modernity, time is experienced differently at different places. And as I draw my remarks to conclusion, what I would like to say my final sentence is, for me it's very helpful to connect this with most of the developments in the planet. So sequential and heterogeneous time, in Chatterjee's terms, are the experiences of most people in most places, not in the West. And so what I want to develop in the paper are ways of linking those experiences, often under the term of globalization below, and to consider the extent to which we can code that in constitutional terms. But in the interest of time, I will save that for discussion.
Lovely. Thank you, Gavin. Margot, please. Jenny, if you could just push the mic over. Thank you.
So I'd like to begin as every other speaker has, but to do so really very sincerely in thanking the organizers of this symposium and the number of people behind the organizers who made it possible. I'm really thrilled to be here, and coming at the end of the day, I feel I'm ideally positioned to say just what a wonderfully valuable and engaging day this has been. And so I hope it doesn't go downhill from this point, but I'll try to keep to the standard already set. And I come here today having been tasked with talking a bit about social justice and the Charter. And I want to begin with the dual observation that it's not as if the court hasn't had the right case to make a decision respecting some novel social justice issues, nor is it that the right doctrinal arguments haven't, in one form or another, been tried out. And yet when we look back with the 30 years of perspective that we have at this point at social justice claims under the Charter, we see that victories indeed are few. And this is not the future that many of the social activists involved in the negotiations and the politics around the passage of the Charter of Rights and Freedoms, this is not the future they looked forward to. And so the question, I think, is really an important one. Why has the field of charter litigation been so barren a ground for social justice intervention? It's obvious that charter litigation has emerged as both a tool and a terrain for social justice claims. And really, regardless of whether or not we decry the influence that the courts have under the Charter over these sorts of issues, I think we can't deny that under the current mock-up, it's no small concern what judges are pronouncing. And so I guess, Gavin, there's my air of resignation, just to link back to your starting foray. So I'm taking up the question of the scarcity and the paucity of successful social justice rights claims under the Charter. And I do so by looking at sections 7 and 15 in particular. These sections are, of course, key to the discussion because although our charter contains no explicit text granting social and economic rights, activists have looked to sections 7 and 15 as kinds of ciphers or expandable text for rendering the charter more responsive to the social injustices of the 21st century. My paper spends some time, or at least promises in its current incomplete form, to spend some time talking about the notion of social justice, and I'll point out only here that it is a term that the Supreme Court of Canada itself uses not infrequently, but it's not a term that the court is at all expansive about or really gives us any indication of what it means by it. I'm thinking of the notion of social justice along the lines set out by Janine Brodie in a series of articles where she talks about how important it is to conjoin the term social to the notion of justice, and that really the notion of social justice with both of those elements of the term equally emphasized gives us a sense of the key political goal of, and here I quote Janine Brodie, addressing the inherent gap between liberalism's promise of citizen equality and the structural inequalities of capitalism. As I've already noted, cases have been unsuccessful in really getting some firm ground for these issues to take root and to result in change. Section 15 appears really to be a stalled set of doctrine. The Supreme Court seems stymied about what to do, and Section 7, while more promising, at least recently, still has some important qualifications that pertain to this issue. Now, this paper is not an attempt to sort of exhaustively explore jurisprudence under these sections, but really what I'm trying to do is come up with a sort of central observation about the challenge social justice claims face under the Charter, and then to see how this central, more theoretical observation has played out or manifested concretely in terms of a couple of specific doctrinal moves that characterize cases under 15 and Section 7. So very quickly spun then, my claim is that the courts in social justice cases have failed to contemplate adequately the social and political form in which oppression and social injustice occur. And that central to this failure on the court's part is their inability to really theorize and address fully the manner in which individual harm and systemic fields of social power hierarchies co-occur. So they've really failed to take adequate note of the confounding of individual and systemic features of injustice, and the result has been really overly simplistic and thin, and ultimately, I'd argue, unsatisfactory contemplation of the harms that are at stake in these cases. So then, really, my initial argument is simply that key to any social justice claim has to be a nuanced and effective treatment of the relationship between individual harm and systemic fields of social power. And equality theorists, particularly those from the legal discipline, are actually well-schooled in this argument and have written quite extensively about the complex placement of persons and groups in broader patterns of hierarchy and oppression, that there really is no ground zero, as it were, at which historical and social context and group membership are irrelevant. And I think there are really three observations that have emerged from this field of scholarship, and I'm just going to reiterate them here because I think they're important and they bear emphasis and repetition. The first observation is that individual identity is multiple, fractured, and infinite. It means not simply that the world is diverse, which of course it is in an incredibly wonderful and a fabulous way to be celebrated, but it means that there's no one vector of identity or of experience that will capture any individual circumstance, and that we're all marked, whether we explicitly acknowledge ourselves as such or not, we're all marked really by every one of the lines of identity that get articulated. That's the first observation. The second observation is that these identity features and their effect are patterned. And by this I mean that power and privilege and correspondingly discrimination and disadvantage are distributed repetitively along different sets of lines of identity. So there's a history and a flow. Discrimination is not randomly distributed, but rather piles up in the same channels. The third and last observation is that these structures of power are mutually reinforcing. The most disadvantaged individuals and groups will typically experience stigmatization or discrimination, for example, along several identity vectors, as it were, at the same time. Oppressions are overlocking, they stack up one on the other. And if you think of it as a sort of tangle, there's no way to pull one string of the tangle that will sort out and render the problem fixable. The jumble, as it were, is uniquely configured and really created in each circumstance by mutually entwined knots and twists and threadings, to continue the metaphor. I guess, it's also important to acknowledge that, and the obvious point, which is that these observations are not novel and they're not particularly starting. They're not unique to my thinking on this, but as I said before, I think they're basic and they're unavoidable. And it is my argument that the courts have really not contemplated clearly in their doctrinal elaborations this particular set of conceptual points. In specific, there are two doctrinal boxes, as it were, that I see social justice litigation under both sections 15 and 7 being trapped. And these are the boxes of the sort of task of comparison, particularly as it figures in section 15, and then the rubric of choice as it circulates in both section 15 and section 7 cases. I'll talk just first very briefly about the notion of comparison. Of course, the Supreme Court of Canada has been insistent that section 15 is a comparative concept. I think this is probably right. I think there's a solid and sensible division of tasks between 15 and 7 that really depends upon retaining this comparative notion of section 15. But the problem is, however, that in doing the comparative analysis, the court set up too thin or simple a choice of individual characteristics on which to rest the analysis. The difficulty, I guess, is as well that too thick a selection of individual characteristics might be unmanageable and render the operation simply undoable. The response has been for both theorists and judges to talk about intersectionality, this recognition that individuals sit at a kind of intersection of different identity categories, and one needs to understand and configure the harm complained of in that term. But I would still argue that the courts have really been inadequate in spelling this out, and that the complex nature of oppression and its relationship to identity make this comparative analysis dicey from the perspective of acknowledging appropriately the sorts of harms that social justice claims bring to the court. And my paper goes on to elaborate how this happens specifically in the Gosselin case. And in the Gosselin case, I'm struck by the observation that it is often the most burdened and those most in need of, say, the equality rights who suffer from this conceptual shortcoming, or at least doctrinal shortcoming, and that the pole gets set up between those whose equality harms are most easily recognized as the sort of but-for individuals who are mostly the same, and then those who really figure as examples of the stacked and compounded oppression become unrecognizable, their harm dismissed simply as possibly just them or idiosyncratic, and not part of something Section 15 ought to address. And so that's where my discussion of Gosselin takes me. I also, in this part of the paper, look a bit at Section 7. And my argument here is that the multiple nature of individual identity is also critical to Section 7 discussions. And we can see this in the rich, complex context that the courts in, say, the Insight case or the Adams case out of British Columbia employ in understanding the sort of harm that's at issue under Section 7, but I argue that there's a kind of irony that the use of this complexity of context actually also features to really render choice important in a way that denies the complexity of context that prefigures choice. And so there's a way in which the shaping of the identity groups of the complainants also segues into an inappropriate emphasis on choice and a failure to recognize the subtleties of the harm at issue. So in Adams, for example, which is a case about overhead shelter, temporary overhead shelter for people who are sleeping in parks, the court really ignores the way in which gender and disability and health issues might actually configure the equation it draws between available shelter beds, or the availability of shelter beds, and the constitutional right to temporary overhead shelter. The last piece of my paper takes up this idea of choice, and I suppose, Robert, I'm taking your comments to heart. This is maybe the most contentious part of my argument, and that is, I want to argue that not only is choice a tricky concept under both Section 15 and Section 7 in terms of determining whether or not there's government obligation to address the harm being proffered to the court in the claim, I want to assert more strongly that choice ought not ever to be an important metric to the substance of whether or not there's been a Section 7 infringement or a Section 15 infringement, such that there's some state obligation to justify that infringement. So my time is out, but I'm going to leave my discussion then at what I think is probably the most controversial part, but it's also something that I've over the years come to feel most strongly about, the way in which choice, individual choice, features as a kind of spoiler of individual rights, claims, and actually inserts a sort of double kick at the can of state action, as it were, back into the context of substantive rights infringements in a way that I think does not promise well for the Charter being any kind of really substantively valuable or transformative tool or terrain for social justice innovations.
Wonderful. Well, both speakers have left us lots to pull on in our discussion, but happily we'll begin that kind of reflection and discussion with Jenny, please.
Thanks. So these were both really interesting papers. And I have to say, listening to Gavin, I think you couldn't really tell the richness and detail of what he does with a kind of overview of constitutional scholarship and its different historical trajectories. And so I recommend that to you. I'm not going to try to parse that as such. So what I want to say is that, beginning with Gavin, is that I think it is extremely important to examine how our concepts and their histories and the ways the concepts fit together function to reinforce certain patterns of how we see things, what we don't see, our patterns of blindness, and in so doing serve to reinforce existing hierarchies of power. And I take that to be a central part of what the big overall project is. And I think he does it in a really interesting way. But I think there are two dimensions of the project that need more emphasis. And so that's what I want to talk about. So the first, really a lot of the paper is in one way or another a kind of discourse analysis. And I think that an interest in discourse should never be a substitute for an engagement with institutional structures of power. Ultimately, discourse matters because it shapes how we see and thus shape the world, and we do so in material ways via institutions and legal regimes. So he mentioned in his oral presentation moving from normative to genealogical, so that's fine, but I think it needs another step, and that step is an institutional step and an empirical institutional step. So I want to just take a step backwards and make a general note about constitutions and constitutionalism. So I think that part of what has happened within the world of both political theory and legal scholarship is that we've become preoccupied with charters and bills of rights. And that's what constitutions are. But that is not what constitutions are. I began my work in this field about the history of the writing of the American Constitution, they weren't going to bother with a Bill of Rights. That was a kind of afterthought, something they're willing to, it was a compromise with the Anti-Federalists. They were interested in the details of how you structure power. Who is going to have, if you structure your electoral districts like this, are the property going to get elected better or not? They were very focused on the relationship between institutions and power, and words about rights were not on the agenda of what constitution making was all about. And I think in the global context, you see often a much deeper engagement. Think constitutional negotiations break down over debates over federalism. Should it be based on geography or should it be based on ethnicity? That this is about institutional structures of power. It's not about words, about rights. And so I think we don't want to get lost in this rights discourse stuff as if that were all a constitution is. And so I embrace the invitation, which we see in both papers, to keep power in the center of our minds when we think about constitutional issues. But for me, when we talk about power, I want to be talking about the concrete, material, institutional ways that power is organized. So the second dimension is normative. Gavin said, rightly, I think, that one of the strains of the kind of post-colonial analysis that he draws on in its eschewing of normativity sometimes falls into what is essentially a weirdly efficiency argument, which is odd in the context. But how well are these things functioning in terms of an efficacy or efficiency standard as opposed to a normative standard because they've eschewed normativity. So in my view, really, you cannot have a conversation about constitutionalism absent normativity. Of course, you recognize it to be contingent and historically produced and constantly under negotiation and contestation, but you can't do it without normativity. And so there I would say that in my own understanding of what constitutionalism is it is various mechanisms for holding democratic decision-making to account. And there are two forms of that holding to account. One is to a set of values. Those are the kinds of things that end up in sort of bills of rights. But it also holds them to account in terms of commitments to institutional structures. The problem, in my view, is that this holding to account, how do you do that? We really have a deep and global poverty of imagination. It's as though judicial review on more or less the American model, now modified little bits here and there, Canada, India, South Africa, proportionality, but basically it's as if judicial review were the only institutional mechanism for holding democratic decision-making to account. And that's just not true. Your former colleague Craig Scott and I years ago wrote a paper coming out of one of the rounds of constitutional negotiation about a very different model of thinking about how to do that in the context of social and economic rights. So I think that although it is a truth of the current historical phenomena that we collapse judicial review and the accountability of constitutionalism, this is a collective failure of imagination about institutional alternatives. And so that brings me back to the need to be moving this discourse talk into the details of institutions and power. Okay, so now I'm going to move to Margot. And interestingly, so maybe this really doesn't have anything to do with their papers, it's just where I am because I'm once again asking for more empirical work. So I think that Margot is right that part of the problem that she identifies in why there's been a failure with respect to social justice is that Canadian courts offer a partial acknowledgement of the centrality of systemic inequality. And now, of course, this partial acknowledgement is huge compared to the total failure, say, with American jurisprudence. So I don't want to denigrate it, but it is partial, and it's partial in part in the ways that Margot helpfully outlines. And I think she's also right that part of the reason it doesn't work well is that the courts are currently not well equipped to understand how systemic inequality and its relationship to multiple categories and vectors of oppression work, and what the role of the law is in sustaining those patterns of systemic subordination, disadvantage, whatever you want to call it. And this is where I really thought that Margot's paper is in effect a call for scholarship that could help the courts do a better job of this. And what I think we need is many, many detailed, concrete examples of exactly how systemic or structural inequality works. So play it out, take a concrete example, and look at what the many different institutional factors, some of which will be legally defined, some of which won't, how are these patterns of subordination sustaining themselves? And if we knew that, if we had before us case after case of this worked out and careful empirical detail, we could worry a whole lot less about apt metaphors, which Margot has a nice little discussion of. And I think that far too much scholarship relies and debates about different kinds of metaphor, about disadvantage and intersectionality and how that works together. It's not additive, it's this, it's that. But none of that is going to do the job until we get better empirical work. And so here I just want to say that, of course, this then reminds me of an old problem. I think I wrote a paper about this 20 years ago, about the ways in which we always run the danger of reifying and essentializing categories of race, of gender, of whatever it is, religion, thank you. And why is it that we keep invoking these categories, which we recognize to be complicated and intersectional, so that no one invocation of gender can do the job and so on? There is actually a straightforward answer to that, which is that we cannot describe the patterns of the structures of hierarchy without these terms. So there it is, right? Every time you use the word race, I do think racialized is a little bit better, but every time you use these words, you reify them as if they were kind of concrete realities as opposed to things created by structures. But we have to use them. And so then this connects to me to the discussion that rose out of Raz's discussion of lists of these categories, right? That's why constitutions have them, with all the problems that arise out of it. And so here's where I wanted to come back to something that arose in a series of our conversations earlier, and that Margot's paper also touches on by thinking about Section 7. And so I was inspired, I think it was really listening to Bruce earlier, to ask the question of whether using Section 7, so liberty, security, can we avoid, so the danger is now use Section 7 for individualistic analysis, which removes you from a comparative power and hierarchy analysis, which is built into good equality jurisprudence. And so the danger is that you fall into a kind of liberal individualism, which is not what you want. But I don't see that that is a necessity, actually. And so I think, to me, one of the things that comes up from Margot's paper, but especially in conversation with the other papers, is whether we might think more creatively about how liberty arguments, with tacit understandings that, of course, liberty is equal liberty for all, could be engaged without tangling ourselves up in the categories that the equality analysis inevitably draws us in to because of our historical frame of where we are. Okay, so finally, I thought that there was a really interesting kind of tacit promise in what Margot did here. And that has to do with economic inequality. So it was interesting to me to hear Robert say, okay, so the two polarities are, we know race is in and poverty is out, right? As that's the spectrum of what equality can go to. And this when I read Margot's paper, I was struck by, back in the early 90s when I was teaching comparative constitutionalism, I thought, how are the Canadian courts going to avoid economic inequality, right? They've got, analogous grounds on the table. They've got historic injustice. So they're going to have to deal with this. And it's weird to me that the absence of property is used as a justification for not looking at inequality. That's the main reason you keep property out of your Constitution, is so that you can get at economic inequality. So that's just perverse reasoning, I think. So here's what I think Margot offers us in tacit form, but in really interesting, which is that I think it raised for me the idea that there might be a role for a strategic argument about how to recognize economic inequality in a way that is, so I'm talking strategic, limited, consistent with the economic inequality that is fundamental to how we currently understand capitalism, right? So whatever the conception of unacceptable economic inequality is, it has to be, at the moment, it has to be consistent with some degree of economic inequality. But so given that, how do you do that? How do you make that move into an engagement with an equality analysis of poverty, basically? And I think what Margot is hinting at is that is intersectionality. Is that there are many, many cases that arise where the only way to, so Gosselin is an example, right? The only way to understand what's at stake is the intersection between the vulnerability of women as for gender, economic inequality, which then sometimes leads to physical insecurity, that the intersectionality story, which the courts do know how to do at one level, can bring economic inequality in the door as a component of intersectionality in a way that we cannot get directly at this historical juncture. And I think Margot kind of gives us a path of how to do that.
Thank you. And as now has been our custom, will Gavin and Margot take a chance for brief remarks if they wish. In response, I'll take a list of questions from anywhere in the room and then turn over to discussion. So Gavin, Margot, if there's anything you'd like to say, and I'll look for interventions.
Well, that was really a wonderful set of insights into my project, and I'm deeply appreciative of it. Thank you. And I guess there are two pieces of it that particularly caught my attention. The first is this idea of what to do with metaphors. So I've thrown into my paper some sort of consideration of metaphors, and in fact, I have a metaphor of my own that I want to put in the paper. But I also want to talk a bit critically about it. And so you've given me a way to think about how to escape metaphors and address some of the shortcomings with them. Although the idea of doing a series of dense empirical studies isn't necessarily an easy solution.
Yeah, we always want somebody else to
Well,
do
that's
that.
exactly, I was going to say, that's maybe not my task, but I'm with you in urging it be done. And the second point, which is, of course, your last point, about a way out of the political conundrum of how to get the court to take on class, really, straightforwardly. And you know, it's interesting because I wasn't sort of conscious that that's what I was doing, but when you say it, I think, yeah, I'm going to take credit for it. Because my thinking about the Section 7 cases in particular, which escape the problem of categorization that is so unavoidable in Section 15, but nonetheless still need to have this rich, dense description of the harm that's being complained of, actually provide this site for putting in economic disadvantage in a way that's simply less politically threatening. And so that the Insight case is really about poverty. That's a poverty case, although it's framed in terms of access to health care. The Adams case is about poverty. And so that's an exciting way to think about where to go with these theoretical observations that actually might enable you to sort of walk in a more concrete way the use of them in relation to some real material and important systemic claims. So thanks.
I'd also like to thank Jenny for a very thoughtful reading of my paper. It's just one of the privileges of being at an event such as this, that you get the chance to see your work in a different and very helpful way. And I find myself agreeing with virtually everything that you said, and in response, I'll partly do the Margaret's response of I can't do everything at once, so but I certainly understand the point you're making. And maybe I can refer to two other distinctions. You picked up in the institutional and the normative. And in doing so, maybe just to mention Mark, because in part the paper was inspired by one line in a paper Mark wrote on the left critique of normativity some 20 years ago, where he said that if the left gave up on normative constitutional theory, quote, it would be replaced by something like sociology. I was quite intrigued by that idea, and 20 years later we have a quite significant turn to sociology that I outlined. But I think there's an important distinction to be made here between, and Martin Laughlin draws this distinction between normativity and normativism. And while taking on board Jenny's comments, I think one of the things I'm wary of is collapsing normative debate, which I absolutely agree we can't avoid, and part of my project is to avoid simply lapsing into efficiency, efficacy arguments, with the type of normativism that I think Jenny outlined, which very much focuses on rights and ex-ante liberal principles. So in some way, the normative argument can't be avoided, but I don't think it's any particular, there's any special arguments that I have to generate normative principles as against anyone engaging in the constitutional project. I don't see it as necessarily a particular claim against the sociological term. I'm just keen to avoid it within that term. But maybe to address the institutional point, and yes, very much I take the point that it's important to bring these observations into the material world. I think just make two observations in that regard. I agree that we shouldn't reduce constitutional scholarship simply to discourse theory. I also think that we shouldn't underestimate the extent to which power structures are within discourse theory. So one of the issues that I'm keen to raise is the extent to which debates, particularly about constitutionalism beyond the state in a transnational context, seem to take a Western template of constitutionalism as the starting point. It seems to be an almost universal assumption that debates in this regard are seen as extensions of debates that originated within North America and Western Europe. And so, obviously, the institutional aspect is an aspect, is an important part of that debate, but I would draw attention to the way in which that starting point itself is a means of perpetuating power relations, and certainly within the post-colonial context, I think that's evident. But related to that, I also think that we shouldn't reduce questions of power and accountability to the institutional forum. And I didn't take Jenny to be suggesting that, but part of the discourses that I'm tracking, particularly with regard to globalization from below, is looking at the extent to which power and accountability arises in extra institutional spaces. Now, I don't want to reduce this to a semantic debate over what is an institution and what isn't, and we could have, to some extent, move into Rumsfeld territory of institutionalized institutions and extra institutional institutions that, for our sanity, it's probably better to avoid at this time of the afternoon. But simply to reinforce Chatterjee's point that he speaks about popular politics. And in addressing popular politics, he seeks to bring to the minority audience, which is us, or Western Europe, North America, the extent to which popular politics are alive and well and generating very interesting extra institutional hybrids. And this term intersectionality, I haven't heard so much before today, but I'm just wondering if that might be one way of addressing that. So, for example, Santos has conducted various empirical studies to look at the way in which indigenous groups, and I think John referred to this in his paper, his written paper, are engaging in, well, hybrid strategies where institutions, formal institutions work fine, but don't see it as the be-all and end-all. And so I think Jenny's point is we can't avoid institutions. I agree with that. We have to take them seriously, but we shouldn't reduce the strategies to them. And so I'm starting at the other end, trying to move towards that rather than necessarily beginning with the institutional. But again, thank you very much. Very helpful.
So I'm going to invite our first person on the list, Faisal Baba. But if anyone else wants in on questions, we have space on the speakers list. So.
Thank you, and thanks for really terrific panel presentations and comments. Margot, I wanted to follow up with you on your talk. It's a subject that I am interested in as well, and I think I generally agree with your observations that there have been more disappointments than celebrations coming out as a result of social rights adjudication, at least under Section 15, and at least with respect to systemic changes regarding social rights, economic redistribution. I guess I just want to ask you to comment on a couple of ways that Section 15 has, I think, operated in ways that may offer some promise, or at least, and ways that may also offer double-edged swords and some concern. And one is specifically the duty to accommodate and the manifestation of an equality claim as a claim based on this duty and exacting a cost from either the state through a Section 15 claim, or increasingly and more significantly and of particular interest to me, exacting a cost from fellow citizens through private anti-discrimination claims. And we see economic redistribution of sorts happening through the ability of people to independently file claims that literally could result in private citizens, companies having to pay people who have been in relationships with them. And I'm looking mostly in the employment context. So while we don't have the ability for a group of poor people to get together and claim a right to work, give me a job, give us a job, we are systemically excluded. When those people obtain jobs, if they enter into even job competitions and are denied jobs, they have a hook. They can file a private discrimination claim, and I would echo Jenny's call for greater empirical work in this area. I think it would be very interesting to study the extent to which the numbers, if we look at private human rights claims and look at patterns, the grounds, and the kinds of facts that are being alleged, whether we would see anything about the way economically marginalized people are acting, if not in concert, at least in similar ways, using the law, deploying the law in similar ways. And then the other place that I would look is is outside the institution, into the streets, into the fields of activism. And I would suggest that Section 15 and equality language, it has created a discourse, an empowering vocabulary that has, and there's been a lot of writing on this in Law and Society, not so much in Canada. I'm not sure how much, and I wonder if looking at that, at the extent to which poor people, socially and economically marginalized people, have been empowered through the language of anti-discrimination and equality to make stronger claims, more vocal claims, even if ultimately their litigation is unsuccessful.
Thank you. Mark?
Thanks. This is a comment provoked by Gavin's paper and at some level triggered by some things explicitly in it and by the title, The New Borders of the Constitutional. So the question or observation is in the form of a provocation. Is it coherent to think about domestic constitutionalism anymore? Not merely with respect to social justice, but with respect to a whole range of other things. So just to give you some examples of what occur to me, to the extent that there remains a Washington neoliberal consensus, national constitutions respond to that consensus. Second, there's this now, I don't know how many there are, but a bunch of decisions by European constitutional courts about the domestic constitutionality of whatever it is that the EU has been doing in response to the Euro crisis. Most recently, the German Constitutional Court. The final item is the U.S. free speech law and this video thing, so there's enough going on that maybe that the border between domestic and, I don't know what the right word would be, that the border around a domestic constitution is now, the provocation version is completely porous, so that there's nothing within a domestic constitution that cannot, under some circumstances, be the analysis of which can be confined to domestic issues or domestic law.
So I'm just, before I take a chance to respond to both of those, maybe put a couple of other things briefly on the table. Margot, more of a comment than anything. I think something that you didn't have time for in your presentation that I think is very interesting is thinking about choice as a marker for state action, or this, what you described it very briefly as a kind of second kick at the can in thinking about what is state action in the context of constitutionalism. And I think that's a really interesting, powerful part of the paper. I don't know if you want to say a bit more about it, but the questions actually were, I had two that I'll put your way, Gavin. One was whether or not, I guess it has to do with the question of the adjective of critical that's still engaged in this and how it is reshaped and redeployed. And specifically, I wonder whether or not the focus on modernity, construction of the modernity, on the global, take some of the local political heat that was one of the signal features of the critical project out of that critical project. In a sense, do they seed that kind of local or social register in the micro level in favor of the epistemological reorientation that you're arguing? In a sense, does that reorientation enfeeble the critical project at the local political level at some form? And related, I just wanted to draw a link up with John's work, which was to suggest that in some ways, something that you mentioned in answer to one question very briefly, it seems to me that there's a lot in what you're saying that suggests that if there is a critical project that takes on this epistemological reorientation that's about multiple modernities and about porous laws in some of the ways that Mark has described, that critical constitutionalism is in this fourth phase that you described, naturally suited to have Indigenous and Aboriginal issues very much at the heart of the project in some of the ways that John's work has brought forward. Jenny, please.
So I wanted to just add to the choice issue. So when we were talking earlier about immutable characteristics, I was reminded of a really interesting panel I heard at Law and Society about studies of people's self-identification in terms of sexual orientation. And the finding was, over a 5-year period, it changes. This just doesn't turn out to be anything like an immutable characteristic. And the problems that poses for American jurisprudence, which is so heavily invested in it. But in the context of this, one of the panelists was saying, well, that whole thing about immutable characteristics was a mistake. This should be an autonomy argument. This should be a choice argument. The reason why our sexual lives shouldn't be regulated by the state is because for autonomy reasons. Now somebody else responded, oh, well, we got to be worried about that. We don't want to bring in libertarianism. But I think, part of the answer is if autonomy is relational autonomy, if choice is not, a decontextualized individual choice, then we can bring it back in. And the bottom line is I don't think we can do it without it. And I'm not sure whether you think you have a way of preventing the bad uses of choice that you're talking about from the necessary protections of autonomy.
So Margot and Gavin,
Okay,
please.
so I'm going to go to that comment since it's the most recent. And so that's a different criticism than the one that Robert leveled this morning. Because I wrote a paper on the Insight case, and I actually came up against this issue, this sort of double-edged choice. So in fact, importantly, what Section 7 ought to do is protect intimate choices, and yet at the same time, I want to say I don't want choice actually to figure as a spoiler of the application of state obligation to redress this harm, this injustice, harm of injustice. And so I have to figure that out. And I have to figure it out in such a way that I'm not sort of having, having my metaphors come to mind. And also your work on the sort of unbounded self, that notion of autonomy is obviously very relevant and a piece of the literature around the discussion of the way in which the individual and systemic oppression circle with and are joined together. And so, that's a piece of the paper I think that needs a little bit more careful elaboration. But clearly those are issues. And I don't have an answer to it, except that I'm very clearly even offended by the way choice is currently used. And I'm doubtful that the courts will ever be able to use it in an adequate way, so that I'd rather just take it out. Not in terms of protecting the sort of intimate autonomous choices, but in terms of disentitling a claim of harm that should be redressed collectively. So maybe I can't keep that balance, or do that high wire act, but that's what I want to do. And Faisal, I'm just going to go back to your comment. You're more optimistic than I am about the impact of the successful charter cases and human rights claims. I see the piece by Brodsky and Day, and actually the discussion that Abigail gave around the problem of reinscribing hierarchy through the pretense of change that's merely just tinkering at the individual level, really being much more descriptive of what's ongoing, both in terms of human rights claims and in terms of successful charter cases than I think you would. So it's I don't disagree that there are always costs involved. I think that I maybe would be more skeptical about issues around access and about actual systemic impact than you would be. And in terms of the empowering that charter language and the categories of identity that the charter makes more concrete at the grassroots level, I think that's true. And I remember being at a discussion years ago with an anti-poverty group where someone said they were using Section 15 to decide who got a donated couch in a community office, and that they were using the principles of then Andrews to determine who in their community best should. And I thought that is so moving, because it's that the charter actually has some real concrete meaning, and yet it's so not a difference that the charter, so yes, the charter language has been definitely embraced and seen as a mechanism of empowerment, but to the extent to which it actually has done that, I'm quite skeptical, but I'm impressed by, nonetheless, how significantly seriously these promises are taken by people for whom they would really make a difference if they were materially achieved.
Gavin, any brief final comments?
Sure. Thank you both to Ben and Mark. Very helpful, provocative questions. Taking some of the points together, I very rarely write about domestic constitutionalism. I thought because the symposium was on the Canadian Charter, it'd be rude not to, and tried not to for the whole paper. So I agree, but I don't think it means the borders are dissolved. I mean, I'd probably note in passing, given your comments to Margot, it's not been a good day for metaphor in general, but I wouldn't therefore move entirely to the literal in terms of the dissolution of borders. I think it depends who you are, where you are, and what the issue is. And that increasingly the constitutional is across borders, both formal and informal or unappreciated. So coming to the specific question Ben asked me about Indigenous peoples, and I'm thinking of a lot of work's been done on the Uwa peoples, I think in Colombia, which I mentioned in the abstract in passing. But there I think you see a very clear example of how the local, the national, the transnational are all tied up. This is an example of Indigenous people who are resisting oil exploration on their land. So part of it is fighting the municipality, part of it is fighting the Colombian state, but with different strategies in terms of judicial and political institutions. Part of the strategy is, for example, picketing the Democratic National Convention or mobilizing transnational coalitions. I think it becomes very pragmatic and strategic within that pragmatism what level works more clearly. So I don't think I'm anti-statist in the sense of I think the state is irrelevant. For example, in Scotland at the moment, we're having quite an intense debate about the future status of the border between the Tweed and the Solway, and whether you're required to show a passport when you go across it or not. So in that context, it matters. But of course, for many citizens within Scotland, it's the Court of Justice in Luxembourg, which, as you mentioned, is the more important. So I think I would be pluralistic there. I think it very much depends and emphasise the porosity. But I think that brings me back to Ben's question about the critical and whether focusing on the global, I think he said, would take the heat out of some of the more domestic municipal debates. I think I say it need not. And coming back to that same example, I think it's a potential danger. But I think what I'm interested in exploring in the paper is precisely what it means to be critical and very much maintaining that frame of over and within. And so I think at various levels we can see these debates, the intersection between questions of over and within. And if that debate remains live, I think then the critical project itself is still flourishing to some extent.
Well, thank you. The break that's about to happen is not a health break. It is a refueling energy, reinvigorate break. And
there'll be more coffee out
there is. We've been re-upped on our coffee and such. In the context of our afternoon of thanks and of appreciation, I just want to say a word of thanks to our IT folks. Including our friend, thanks, and also to Peter Lee, who is our facilities manager and has done all of the work around this. So at 4 o'clock, we're going to come to our final session to hear Michael Ignatieff.